I'll try to keep this argument concise, although you'll see from the opposition brief that there are a number of arguments that favor the state. And so the way I try to organize the brief is to basically walk you through all the ways in which this motion can and should be denied. The first way is that the 911 call itself alone establishes reasonable suspicion for the stop. And we've already established that the trooper received the 911 call. He understood from his own recollection that there were some fluctuations in speed. He then recalled specifically hearing the transmission that we played for him that also referred to swerving within the lane, and that provided him with the basis to conduct a stop. He received 4 things: a vehicle description, a license plate number, a direction the vehicle was moving, and also the general location of the vehicle. And in addition, the 5th thing he received is a description of what the vehicle was doing. It was swerving and fluctuating in speed. That, under the Prado-Navarrete decision, is sufficient reasonable suspicion. Remember, reasonable suspicion is less than probable cause, which is less than preponderance of the evidence. The Supreme Court has described probable cause as a fair probability and said that reasonable suspicion is, quote, obviously less demanding. So I think just based on the 911 call, there was a sufficient reason for the officer to conduct the stop. There's no Fourth Amendment violation. I'll quickly take you through the rest of the analysis, which I don't think the court needs to address. The state's position is there was a traffic violation in this situation, and it's failure to maintain a lane. It's well briefed. Look to the opposition brief. In this case, we have a crossing of the lane line, the fog line. We have touching lane lines on both sides, and we have weaving within the lane. I would maintain that all of those circumstances taken together in a totality of the circumstances analysis is sufficient to show a violation. And there's actually good authority, including from the Nevada Supreme Court, which in dicta in the Alejandro case said that crossing the line even once was apparently a violation. But I would submit that even if it's not a violation, there's a reasonable mistake of fact that it is a violation. And I think the Hine case, which is very clear, the Supreme Court said that officers who make reasonable mistakes about the law and about the scope of the law, so long as that mistake is reasonable, it can give rise to reasonable suspicion. Reasonable suspicion can rest on a reasonable mistake of law. And I think that's what we have in this case. And if you look to footnotes 1 and 2 of my opposition brief, you'll see that a number of jurisdictions have interpreted the very same language as our failure to maintain statute to mean that a single crossing of the lane line is a violation. And in Illinois and also in Georgia, the courts have interpreted touching the lane line to be a violation. So I think that if there is a mistake, it would be a reasonable mistake. And under the Supreme Court's precedent in Hine, there's no Fourth Amendment violation. You don't even need to reach that, Your Honor, because even if it's not a violation of failure to maintain, it's erratic driving. And as the Nevada Supreme Court said in the Rincon case, absent evidence of a traffic violation, there must be additional indicia of erratic driving or unusual behavior. You saw the video. You saw lane touching. You saw drifting. You also saw an attempt at the very end to change from the number 1 lane to the number 2 lane, a sudden change of mind, and then a sharp veering back to the left. That's erratic driving that gave the officer reasonable suspicion, even if he wasn't buttressed by the 911 call and his suspected traffic violation. Finally, I'll just point out it's a totality of the circumstances analysis. You look to the 911 call, to the driving pattern, and you look to all the other circumstances that attend this particular traffic stop. And my final point would be that even if there were a Fourth Amendment violation, which the state maintains there is not, suppression is not the proper remedy. So we don't believe that any right of the defendant has been violated. But even if there was a right violation, the next question is remedy. And the Supreme Court has cautioned against the indiscriminate application of the exclusionary rule because it's such a high cost to the truth-seeking and law enforcement purposes that the criminal justice system is here to enforce. So we would argue that under the cases, the Supreme Court's precedents in Davis, Kroll, Leon, and the Nevada Supreme Court's precedent in Byers, there would be a good faith exception here. I've given the court plenty of case law and facts to find that there was a reasonable stop here and no Fourth Amendment violation on that will submit. Thank you.
Mr. Schaerer, thank you.
You'll notice from the defense's presentation there was no discussion of the other factors that gave rise to reasonable suspicion. It seems that the defense has a divide and conquer strategy for trying to defeat reasonable suspicion, which is a very low standard based on isolating whether or not there was a traffic violation. Now, that point is largely irrelevant because even if there were no traffic violation under the United States Supreme Court case in Hine, the reasonable mistake of law as to the traffic violation would furnish sufficient reasonable suspicion. But the court doesn't need to do that. What I tried to do with my opposition brief is give the court a menu of options to insulate its decision in this case as to why there is reasonable suspicion. Let's just focus on the driving pattern. Regardless of whether it rises to a traffic violation, the driving pattern gives reasonable suspicion for the traffic stop alone, full stop. And I would cite the Nevada Supreme Court's case here in State v. Rincon, where the Nevada Supreme Court acknowledged that erratic driving gives rise to reasonable suspicion for a stop. And I think I want just to point out briefly for the court is it describes what would be erratic driving, and it describes it as swerving in the travel lane, which is the information that the officer had from the 911 call, and also what the officer observed with the slow drifting back and forth within the lane, something that was not addressed by the defense. It also refers to weaving within or outside the travel lane. Notice it says weaving within the travel lane. That's what the officer observed. So just based on Rincon and the driving pattern, regardless of whether it's a traffic violation, which I submit it is, there's reasonable suspicion. Rincon is absent a traffic violation. There must be some indicia of erratic driving or unusual behavior. That's what we have here. And then also there was no discussion of the 911 call. And in the United States Supreme Court case of Prado Navarrete, the only basis for the stop was a 911 call. The officer did not observe anything on his own. He simply listened to the fact that someone had called in 911, said they had been run off the road, and found the vehicle that matched that description, then conducted the traffic stop. And the Supreme Court said because it was on a reliable emergency 911 response system, it was contemporaneous reporting, and the person who was calling was an eyewitness, those three factors, that the 911 call, even if anonymous, bore sufficient indicia of reliability, and thus gave reasonable suspicion for the stop. So I think you have two very good bases here that stand alone. They can be independent. But I think when you combine them together, the 911 call, the driving pattern, possible traffic violation, reasonable mistake about the traffic violation under Hine, I think the case law and the facts are overwhelmingly in favor of the state's position, and I would respectfully ask the court